Martin's business crime practice involves all aspects of fraud, money laundering, bribery and corruption at basically every stage: investigation, trial and enforcement. He represents prosecuting agencies, individuals and corporates. He's a leading expert on proceeds of crime, and he is a contributing editor of Archbold, but you can't have everything. And as I say, he is the co-author and very much this year the author of Corporate Criminal Liability. And I can't think of a better person to talk about our next topic, keeping prosecutors at bay. Martin.
Thanks very much, Amanda, and to Elizabeth. It is really an enormous pleasure for me to introduce this first panel discussion. First, because I am delighted, I know that it's going to be really interesting, but second, because I am only having to introduce everybody rather than think about the answers to the questions. That is going to be the responsibility of our three panelists. I can see two of them have come on screen. Nina, you're not yet there, but I'm going to start with some introductions. First, Katya Jestin. Good morning. Yes, good morning, Katya. Katya was previously an assistant US attorney and supervisor in the criminal division of the Eastern District of New York, but is now managing partner at Jenner & Block in New York and a member of the firm's investigations, compliance and defense team. She advises companies and executives in criminal, regulatory and congressional investigations, including representing clients before the US Department of Justice, the Securities and Exchange Commission, and the US Senate Permanent Subcommittee on Investigations. Some years ago, she served as counsel to the examiner in the Lehman Brothers bankruptcy examination, but more recently led an investigation for a large tech company, representing the company in a federal grand jury investigation, and a private equity firm in an international money laundering and FCPA investigation. Nina, there you are. Nina Marino is founder and partner at Kaplan Marino, a boutique white-collar law firm in Beverly Hills with an office a stone's throw from Rodeo Drive, popular in my family. Nina focuses on white-collar criminal litigation in both federal and state courts and has a vast experience of negotiating on behalf of clients with the DOJ, state attorneys general, district attorneys, and Interpol. She is the holder of more accolades than there is time for me to read them out, including top white-collar lawyer in Los Angeles. But for me, amongst her most admirable traits is her willingness to join our panel today, despite it being barely 5 o'clock in Los Angeles, and we've already been online for some time. So, Nina, thank you very much. Last but certainly not least, Anthony Cole. Practiced in London for several years before moving to Canada over a decade ago, and is now the national co-lead for Dentons White-Collar Crime and Government Investigations Group, working out of Calgary working out of the Calgary office, which for those of you whose geography is poor, or like me need to look it up, is way over on the west side of Canada, a very long way from the sea, but also very early in the morning. So Anthony, thank you to you also for a very early start. And Anthony specializes in anti-money laundering and anti-corruption matters, including the recent successful defense of Nico Resources Canada against corruption allegations brought by the Bangladesh government. He frequently advises clients on corporate compliance programs and risk management strategies, including in the context of compliance remediation of efforts running in parallel to law enforcement investigations. He's also the current chair of Transparency International's Canada Legal Committee. So our panel, thank you all of you for joining us. Two delegates, of whom I can see there are some 80 or 90 now. We would welcome questions, but could I invite you, or those of you who do have questions, please to use the chat function, but could you choose the address all panelists rather than delegates? And then that way we can see them on our screens as we go along. Introductions out of the way, but equally to some extent by way of introduction, I'm going to start by asking for a thumbnail sketch of the different foundations for corporate criminal liability in first the US and then in Canada, because it seems to me that those different setups are one of the drivers, if not the prime driver, for the response to corporate criminal liability in North America. So Katya, can I start by asking you, please, to give us an outline of what the US basis for corporate liability is?
Absolutely, and good morning and good afternoon to everyone. Thank you, Martin, for such a kind introduction. I'm so happy to be here today. So the United States Justice Department has a very powerful cudgel when it comes to corporate criminal liability that's predicated on the doctrine of respondeat superior liability, which in essence means that a company can be criminally liable for the actions of its employees or agents, so long as those actions were taken within the scope of their employment and with the intent, doesn't actually have to manifest, but with the intent to at least in part benefit the company. It's a very broad and flexible doctrine, and it's often paired with the government's willingness to collectivize knowledge among the employees or agents of a company when they determine whether a company has criminal exposure. So because of that cudgel, the Department of Justice has a lot of power to investigate companies, and companies respond in a way that reflects their understanding of that exposure risk. And that is generally companies determine to cooperate in these investigations because of the risks of trial, which I know we're going to talk about a little bit later. But because the doctrine is so flexible and so powerful, DOJ can exercise a lot of discretion in determining what to do with companies who are under investigation.
Okay, before turning to Anthony, let me just ask you this. You said that the principle of respondeat superior applies. Is that as broad as it sounds? Can any employee within the company, provided that the actions are both criminal and intending to benefit the company, can any employee, no matter how lowly, be the foundation for prosecutorial action?
That's a great question, Martin, because the answer is yes. One may intuitively think that only the actions of the most senior officials or directors in a company would expose the company to criminal risk. But in fact, that is not what the doctrine holds. And so even a low-level sales representative at a far-off business unit can expose the company to criminal liability. And so therein lies the power of this doctrine. So the answer to your question is any employee in the company, so long as it meets the elements of respondeat superior, can expose the company to criminal risk.
All right, thank you. And we can come back to the question of subsidiaries and so on a little later in the discussion. But Anthony, you've heard what Katya says the position is in the US. How does Canada compare?
Sure. So it's a little different. It's not quite as aggressive or quite as broad. It's a statutory basis in Canada, has been for 20 years or so. The fundamental element of it, or where it departs from the US approach, is that it requires the involvement, some culpability of a senior officer within the company. So that's either directing others to act or before being party to the act themselves, or failing to intervene knowing that someone lower down the food chain is about to commit a criminal act. The notion of senior officer, though, is a statutory definition, and I always think it's a little bit misleading because it's not as it doesn't sort of suggest that the level of authority you need. In the ordinary parlance, senior officer is right at the top of the company, would probably be sort of evoke the idea of the directing mind. It's actually a lesser requirement. It's more directed at mid-level management. The statutory definition defines the notion of a senior officer as someone who is responsible either for corporate policy, or, and it's the second limb here that is the one that's gone, or attached liability, where the involvement is lower down the food chain, and it's where the individual is responsible, the representative, and that can be contractor as well as employee, is responsible for the management of an important aspect of the company's business. And that has been applied in practice in case law to attach corporate criminal liability to acts of representatives at the mid-level management. So territory managers, regional managers have been sufficient to cause corporate criminal liability in decided cases in Canada, which would not have been the case prior to the enactment of the section of the Criminal Code providing a statutory basis. They probably would not have been sufficiently senior to attract corporate criminal liability on the directing mind principle, but subsequent to the enactment of the statutory basis, it's gone lower down the food chain. So I'd say that's the fundamental difference there, somewhere in between directing mind and the US basis of respondeat superior.
I must say I'm very interested in that, not least because just a couple of weeks ago, the Law Commission was asked by the government in this country to carry out an inquiry into corporate criminal liability because it's, I think, increasingly perceived that in England and Wales, that the principles that govern corporate liability, in particular DMW, direct in mind and will, no longer, or at any rate is arguably not fit for purpose. So seeing that two different models from North America, both of which in different ways deal with that problem, my top tip is that the end of this process, which may be a very long process, even longer than the gestation of the fourth edition of the book, we're likely to adopt an alternative system, whether the full setup that they have in the US or something closer to the Canadian model, don't know, but it'll be interesting to see. Anyway, Nina, let me bring you into the conversation to ask, I suppose, the next stage of the process, which is this. Before we can discuss corporate strategies, I think it would be helpful if you gave us some insight into the differing corporate resolutions that the title of this talk has in mind. In other words, perhaps you can help us with the scale of responses from the prosecution in the event, again, of some allegation of criminal wrongdoing on the part of a corporate.
Yes, of course. And hello, Martin, and thank you for that lovely introduction. And hello, Katya and Anthony and everybody out there. Hello, hello. As you can see, it's dark here in Los Angeles. It's pitch black actually right now. So anyway, I'm happy to be here. Thank you so much for having me. So the scale starts on the lowest and happiest end with a declination letter, which is of course what everybody wants, because that says we, the government, are going to leave you alone. One step up from there would be an NPA, a non-prosecution agreement. Up from there would be a DPA, a deferred prosecution agreement. And then after that, the corporation is going to be charged and probably have to plead guilty. So as Katya was saying, and Anthony, to a different extent, there is this concept of the corporation is responsible for its employees. I would point out that the viability of the lesser offensive and or impactful resolutions being an NPA or DPA are in great part driven, and this is responsive to your inquiry, Martin, as to how high level the individuals are that are involved in whatever the wrongdoing is. So if you've got a high-level executive, someone in the C-suite who is involved, aware of the conduct, then your chances of getting the NPA or DPA are reduced, or the terms of that NPA or DPA could be more onerous. So, the lower level employee, would probably, in our structure anyway, lend itself to a good argument that a declination letter would be more appropriate as a resolution. So, whether or not these different resolutions are offered by the government is really determined by 11 different factors. And I don't know if you want me to get into that right now, Martin.
I think we definitely will get into them, but can we come back to them?
Yes, that's why I'm asking.
For sure. Thank you very much for that, because we've heard now that the scale of the cascade, the hierarchy of responses, prosecutorial responses in the US. Anthony, what's the position in Canada?
So we've got a relative, we do have deferred prosecution agreements. They're called remediation agreements for some reason that escapes just about everybody in Canada. We decided to go with a different name. But the deferred prosecution regime is relatively new. It was only introduced about 2 years ago. And it is, I wouldn't say untested for reasons I'll come on to. There is a very famous or notorious case of a decision not to award a DPA to a very large Canadian company, one of the sort of darlings of the Canadian corporate world, SNC-Lavalin. The regime has been tested to some extent, but there has not been a deferred prosecution agreement awarded at this point in time. There are a couple that I think are under consideration, or I know are under consideration, but as of yet, none has been awarded. So there is no such thing as a non-prosecution agreement in Canada. That actually is part of the consultation that went into the setting up of the deferred prosecution agreement regime in Canada was expressly ruled out. So there was some feedback as part of the consultation, and the government decided not to pursue the non-prosecution avenue. So there is no route there. To your point earlier, Martin, the question of corporate, at what level is the offending happening, or at what level did it happen, is therefore a key driver in your strategy in a case. Because if you think you've got a strong argument that it doesn't touch the sort of statutory definition of a senior officer, if there's no sign of an engagement from or involvement at the middle management level, and it's lower down the food chain, then you're looking at trying to convince. You may sort of self-report, as it were, but you're essentially saying it's not a corporate criminal offence. We are just reporting the acts of a renegade impulse. And that will result in, if you're obviously successful there, you're not going to face prosecution. In any other circumstance, the culture in Canada is among the prosecutors is if there is a basis for corporate criminal liability and the charging threshold is met, that is, there's a reasonable prospect of conviction, they will charge. So you are faced with either a DPA, successfully putting yourself in a position to get a deferred prosecution agreement, or you will face charges and the prosecution will resolve, which is what has happened in every single one in which charges have been laid today, as I say, because there's been no DPA awarded. So big corruption cases in Canada, they have all gone to actually guilty plea, at least the corporate ones. The individuals have fought, generally unsuccessfully, the charges. But yeah, it's a binary approach. You're either eligible for a DPA and position yourself well for a DPA, or you are facing charges. There is rarely going to be a circumstance where a prosecutor says, well, the charging threshold is met, the corporate criminal liability threshold is met, but I'm not pursuing this. And you've been such a good corporate citizen that we'll move on. That would be a rare and surprising outcome based on the sort of Canadian approach, the Canadian culture, and the enforcement side.
Well, that leads us neatly on to the next topic that I wanted to ask you about, which is prosecutorial discretion. And I wonder, Katya, Nina's just mentioned declination being the least worst or the best option for a corporate in this context. But to what extent does the attitude of the DOJ set the agenda? And by contrast, to what extent can the corporate and the advisor make any difference?
So because companies generally choose a strategic path that does not include going to trial, the risks attendant to that can be existential. So it's generally not a very appetizing notion, especially for public companies, given the collateral impact of shareholder suits and the other impacts that would come as a result of a trial. Companies generally at the very earliest stage of an investigation decide to cooperate. That's an important strategic decision. It is generally the one taken. There are exceptions, of course, but companies hearken back to the Arthur Andersen case and think about the collateral consequences of actually fighting the government in court. So the trial, so to speak, takes place in the office of the prosecutor. And so it is up to counsel for the company to build a deep level of trust and rapport with that prosecutor, and to establish to that prosecutor that the company indeed has an ethical culture despite the issue that's being investigated, and has a robust compliance program and is willing to take the remedial steps necessary to augment its compliance program and launch itself into a compliant future. That is the job of outside counsel. And so it's critical that they build that level of trust with the prosecutor so that they are believed and listened to. And it's critical that the company listens to the advice of the lawyer and understands how important remediation is in terms of managing the outcomes. Outcomes are significantly improved for companies under investigation by the government if strong remediation is engaged in. In fact, if you look at the FCPA corporate enforcement policy, if a company self-discloses a bribery concern, has a strong compliance program, fully cooperates with the government, absent any aggravating factors, the presumption is a declination. So the DOJ has been trying to bulk up its guidance and bulk up its communications to the bar, that strong compliance and strong remediation will significantly improve outcomes. And the prosecutors have, because of respondeat superior and the flexibility of the legal doctrines, have a lot of power. So it's very important to build that trust.
I was going to ask, or the next aspect for the discussion, is the different, because I understand that certainly in the US, and we'll ask Anthony about the position in Canada in a moment, but in the US, it's my understanding that there's a considerable amount of guidance available for corporates that can be taken on board as part of an ordinary corporate strategy and not merely in the context of corporate wrongdoing.
There really is, and it's not statutory, it's guidance. And the Justice Manual, for example, contains a whole chapter on what a robust compliance program should look like. It was updated this summer in 2020, and it's quite detailed. And so we commend it to our clients. We try to help our corporate clients build strong programs before something terrible happens, so that they're well positioned to confront a corporate crisis should one arise. But there's quite a lot of detail in the Justice Manual. And then high-level DOJ officials like to issue memos while they're there that bears their name. It's a mark of their tenure.
Sure.
So we have
can I interrupt, Katya, just to move on to Anthony for the Canadian position, and then I'm particularly going to ask Nina, because I had to ask in our preliminary conversation, I was being bombarded with terms, most of which I'd not heard of before, and I was particularly interested in Yates and Rosenstein, and I'm going to ask Nina about them and their impact on this in just a moment. But Anthony, how does the position in Canada compare? We've heard from Katya just now that there's a considerable amount of guidance available from the DOJ and elsewhere as to the attitude to to compliance and self-reporting and so on. What's the position in Canada?
Radically different. So there is a complete absence of guidance around DPAs in Canada. There is a statutory criteria, so it's a decision for the prosecutor to make, and I'll come on to why that is particularly challenging in the context of decisions around how to conduct oneself upon discovery of potential corruption or similar economic crime. But the statutory criteria there within the statute, and that includes the things you'd expect, evidence of robust remediation steps, the severity of the acts in question, the degree of involvement of senior people within the company. It's not so much self-reporting as the circumstances in which the wrongdoing was brought to the attention of the investigative body. All those things are criteria that as well as disciplinary action against employees, wrongdoing employees, but those are the statutory criteria. Beyond how those are weighed is a question of prosecutorial discretion, and actually that has gone it's a decided case that it is an absolute exercise of prosecutorial discretion. So it is in the hands of the prosecutor, and it is not subject to appeal absent abuse of process or judicial review, absence of abuse of process. But in terms of how those are weighed, there is a complete gap in the Canadian landscape, such that one has to then understand, how a prosecutor is going to approach this issue, and to establish. Katya mentioned developing a rapport with the prosecutor. It is particularly difficult in Canada for one reason, and that is that the investigative body is not the same as the prosecuting agency. You have the RCMP, who has exclusive jurisdiction to conduct and lay charges for Corruption of Foreign Public Officials Act offences. Whereas, so you are dealing with the RCMP through your cooperation in the investigation as you're going through remediating as well. That is your audience. The RCMP are your audience. They will then transfer the file to the prosecutor, who makes the decision on whether you get a remediation agreement or not. So you have limited access to your prosecutor in the process of carrying what is typically a very long investigation. These as they are in England, as they are in the US, they're often multi-year investigations, and you're generally, you do have an opportunity to engage with the prosecutor periodically. They occupy an advisory role to the RCMP during the course of the investigation, but it is limited, and your access is to the RCMP. So you have to manage two sets of expectations and two sets of I wouldn't say personalities, but certainly, two, and they're not competing so much as different perspectives within the course of an investigation with a view to trying to get a DPA ultimately.
Before moving on to asking Nina a question, just on that point, Anthony, is it not the practice within those two responsible organisations, the prosecutors and the investigators, in attenuate a substantial case, for a lawyer not to be assigned at an early stage to the investigation, so as to be able to both advise the investigators, but also to engage, to the extent that there is involvement of a corporate, to engage with the corporate with a view to a resolution?
Yeah, I think I expect the process will evolve. So the RCMP have advisory, so they have an advisory crown, again from the Public Prosecution Service, so that's the Federal Prosecution Agency. They will have an advisory crown typically in a complex economic crime case along the way, and it may be a different prosecutor that ultimately prosecutes the case. The DPA regime as well requires the decision to be made ultimately by the Director of Public Prosecution. So again, it's not your line prosecutor who's making the decision, it's the DPP. So it's again, you're given access to an audience, but it's not necessarily the one that is going to make the decision. So there is some engagement along the way, and I think it's going to evolve. I think there's going to have to be a change, because if they want the DPA regime to be successful, there's going to have to be greater engagement from the prosecutors at an early stage, to give the companies confidence that, notwithstanding what the RCMP is saying, they're going to get similarly favourable or unfavourable reaction from the prosecutor, because it is disincentive. Frankly, it is a serious risk, and it's part of the the difficulty of advising is the RCMP may be telling you you're doing everything right, but I can't tell you that and they will continually say, if we think you're doing everything right, but you may get, at the back of your mind, you're thinking, well, what happens if a prosecutor sees this differently?
Sure. Well, we're going to come on to the case you mentioned earlier in a little while, the SNC Lavalin case, which might be a paradigm example of where the strategy was got entirely wrong. But Nina, I threatened or promised to come back to you with, still on the topic of prosecutorial discretion. Katya has told us about the different guidance that's available, although not statutory, nevertheless persuasive because it's from the DOJ and so on. But but in terms of granular detail or guidance that's available, I'm dying for you to tell us about Yates and Rosenstein.
Well, I think Yates and Rosenstein is less granular. I think the granular guidance is actually, again, referring back to the Department of Justice manual. And there are 11 factors that the government is supposed to consider in determining what an appropriate resolution is for the corporation. And if you allow me to digress for a moment, I will read those 11 factors because I haven't committed them to memory, because that would be so incredibly boring. So I will read them. And so here they are. The first one is the nature and seriousness of the offense. Second, the pervasiveness of the wrongdoing. So that means, is it a one-off? Is it an anomaly? Is this something that has been going on, something entrenched in the corporation? Recidivism. Has this corporation behaved badly before? Cooperation. Including as to potential wrongdoing by individuals. This harkens back to the Yates memo, which I'll circle back to at the end of the Big 11. Adequacy and effectiveness of the corporation's compliance program. That harkens back to what Katya said and the way she advises her clients to have a strong and robust compliance program, because if you have somebody that's behaving badly within a corporation, that could be your saving grace. Timely voluntary disclosure, that's a real struggle for corporations. It's a real struggle when wrongdoing is uncovered. And, I've certainly been in that situation where the corporation has to weigh, do we bring this forward or do we just hope that it goes away and dies under the rug? That's a real tough one. Remedial actions taken. So should the corporation discover that there's been some bad conduct and instead of voluntarily disclosing, they decide to immediately remediate, that's a plus for them and something that the government will take into consideration as part of the Big 11. Collateral consequences of prosecution. So this is the same kind of argument we would make if we were representing an individual, right? What's going to happen if you take down this corporation? How many people are going to be out of employment? What's going to happen to the stockholders? These are all big questions. Adequacy of alternative remedies, adequacy of prosecution of individuals, and the interests of any victims. So those are the 11 factors. They're referred to as the flip factors. I frankly don't know why. Maybe Katya knows, but those are the factors that the government will take into consideration as to whether or not, what the right resolution is for this corporation. When you're looking at the government's approach, less granular, more generic, or maybe more organic, the approach, it's always been about cooperation, self-reporting, remediation. Those are really bedrocks of the government's approach to corporate wrongdoing. The Yates memo, which came out in 2015, really focused on individual culpability and really mandated that any benefit to the corporation is going to rise and fall on how they disclose their individuals, how they basically throw them under the bus. And so for me, because I mostly represent individuals, this was always, alarming, to say the least. I'll just give you a little side. In preparing for this panel discussion, I did a little research, and I learned, which was surprising to me, and this is just a little aside, then I'll go back to what I was saying. But what I learned is that since 2006, 78% of enforcement actions have resulted in no individual prosecution. That's super interesting, considering that in 2015, the Yates memo was really, that was a bedrock of the Yates memo, individual prosecution. So it's just interesting. So when Rosenstein has his comments in 2020, I think when I'm looking at like 2015 to 2020, or if you're looking even like from 2006 to 2020, I think what we've seen is, like Katya said, nothing's really changed. Strong compliance, remediation, that's still all there. But we're seeing, I think, a more well-rounded approach from the government, a more, I don't want to say softer, because I just can't use the word softer in connection with the Department of Justice ever. But I think we're seeing a more organic, a more thoughtful, a more robust approach to multiple considerations when corporate wrongdoing is either voluntarily disclosed or discovered. Would you agree with that, Katya?
I do, and I have, Nina, I have a thought about the difference, the delta between the number of prosecutions of individuals and the number of corporate resolutions. And the thought is this: because the trial, so to speak, takes place in the office of the prosecutor, when it comes to corporate criminal liability, DOJ oftentimes takes very flexible views of the facts and of the applicable law. And because they are not challenged in court to prove their case, oftentimes they are able to resolve with corporates under whether it's an MPA, a DPA, or a criminal charge, with the comfort that the company is not going to challenge their theory in court. So there's good reason why there are many more corporate resolutions as opposed to individual prosecutions of the folks involved in the conduct being investigated.
I think that's a useful sort of jumping off point, because although the focus is plainly on corporates, I do want to ask about the attitude towards culpable individuals, both in terms of the prosecution attitude and in picking up on the point that Nina, you and Katya have just made, how much interest is there within the corporate domain for prosecuting the individuals, notwithstanding that there are negotiations, discussions going on, and perhaps some resolution as between the corporate and the prosecution. I'd like to know a bit more about the attitudes towards the individuals, and if we have time to perhaps briefly mention something which may send a chill through many, the idea of clawbacks. Mm. So just first, quickly, Anthony, in Canada, do you see that there's a greater emphasis on prosecuting the individuals who are ultimately, responsible, or for prosecuting the corporates, or is it impossible to identify any particular trends?
No, I think it is. There has been a significant interest, even before the DPA regime came into effect, in pursuing individuals. So the first two, corruption of foreign public officials, so Canada's sort of FCPA or UK Bribery Act equivalent, the CFPOA. The first two cases, corporate cases, those did not involve any charges against any individuals. Since then, there has been a change in culture where, in fact, in one case, they went after the individuals first. And in the major case today, the SNC-Lavalin case, they also went after individuals. In fact, in that case, the individual contested. So it went to trial. He lost. The government succeeded in its case, and he was sentenced to 8.5 years, which is a significant sentence. I've also detected significant interest in, particularly with the RCMP in the course of an investigation. It's also baked into the remediation or the DPA criteria that identifying culpable individuals is important to them, as with cooperation. But practically speaking, I've detected significant interest among the RCMP investigating officers in building the case, a very robust case, right from the get-go against the individuals. So I think the early signs are, as I say, the DPA regime is only 2 years old, but we're now well into investigations, and it to me is discernible that they are they're looking at the individuals. So I think the ideal scenario is you get very robust cooperation from the corporation. You get a DPA, but a cornerstone of the DPA is furnishing evidence, identifying individual wrongdoers, and cooperating in their prosecution as well. That's also, a mandatory element of a DPA under the statutory regime, is that ongoing cooperation will be provided in relation to individuals. So I think it is a very high priority to see, even if a DPA is offered, that the individuals, assuming they're within Canadian jurisdiction, will be pursued, and I am seeing that quite demonstrably in the cases I'm involved in.
So Nina, there's Anthony saying that in Canada there's mandatory throwing of employees under the bus. You've already told us that you represent the individuals. So is that the picture? Are you trying to get people from out of the way of the bus?
It's my life's work, getting people from out of the way of the bus. But
is there a tension then between the corporate who's seeking some sort of a resolution, a declination, or an NPA, and your role, and what's going on with the company, what's going on with the individual?
Yeah, it's interesting. So I just had a case that just resolved, and so we had a joint defense agreement. I was representing one of the executives, and we had a joint defense agreement with corporate counsel, which means we were working collaboratively. And so we were sharing information. When I would have a meeting with the government, or they would have a meeting with the government, we would kind of report back to each other, let each other know where the government investigation was going. And then at some point in that journey, the corporation counsel came to me, and they're friends of mine, and they came to me and they said, look, we're going to end the joint defense agreement now because we're entering into negotiations with the government to resolve the matter on behalf of the corporation. And of course, I understand that. That's when the JDA ends. But I will say, most times that works out very, very well. You only end the joint defense agreement when you need to. But if you can support each other, I think it usually works out better for the corporation and the individual if everyone can kind of work together against the government, or at least supporting information, as opposed to everyone fighting with each other, right? It's the same thing if you have individuals in a jury trial and you have multiple defendants. The best day for the government is when all the defendants blame each other, right? They say, no, you did it, no, you did it, no, you did it, no, you did it. The government can just sit back there and then say, well, you guys just go at it, and we'll exactly, we'll take the spoils of war. So I think that it depends on the situation. It can be very contentious. I've had those situations also where there's no joint defense agreement, everybody hates everybody and is blaming everybody else. I think it really, I think a lot of that depends on, and I think Katya mentioned this earlier, what is the ethical culture of the corporation, right? Is the corporation generally ethical? I think you're going to see more collaboration, more cooperation. Is the corporation not so ethical? I think then you're going to see more, throw everybody under the bus sort of responses.
On the subject then, or continuing with the subject of the bus. So Katya, in certainly the last couple of years, there have been increasingly well publicized and sizable foreign bribery resolutions across multiple jurisdictions. And one of the eye-catching ones that's of particular interest to me is the Goldman Sachs case that arising out of the 1MDB scandal. But in relation to that, I think there was there were some particular aspects which are quite interesting in terms of both the DPA, but also the attitude of the prosecutor and the company towards the individuals who were identified as being responsible for what it was that went wrong.
So yes, the Goldman Sachs resolution is very interesting to us, and I'd like to build on something Nina said and I'll talk about the Goldman Sachs resolution in a moment. It's very interesting, the interplay between the company counsel and counsel for the individuals. I think it really depends on the type of conduct we're talking about. When I'm representing the company, we always want our individuals who need counsel to have really good counsel like Nina, because that portends more fruitful and productive conversations between the lawyers and perhaps a coordinated strategy, but perhaps not. If the conduct is severe enough, I think generally speaking, outside counsel to the company will recommend that that individual is terminated or suspended and thrown under the bus, if you will, before the government in order to preserve the company's outcome. Because ultimately, it is going to be all about who you represent at the end of the day. But it's very fact specific for sure. In the Goldman Sachs resolution, outside counsel to Goldman, I think really pulled a hat trick, because the conduct in that matter was very serious. And they, I think, did a very good job negotiating a resolution that protected the parent. So the guilty plea was by the Malaysian subsidiary, which is, is a much better outcome than had the parent been required to plead guilty to a federal felony. The deferred prosecution agreement for the parent is also probably, in the view of outside counsel and the bank, a less bad outcome. Generally, ethical companies and financial institutions are very happy, although it is a cost center, to engage in remediation. They understand the wisdom of augmenting their compliance program and making themselves better and stronger. They oftentimes you hear Rahm Emanuel quoted, and not letting crises go to waste in order to build a better business going forward. And one thing that Goldman did that was interesting is the clawbacks from senior executives of over $100 million in an effort to demonstrate to the Justice Department how seriously they took the matter and how seriously they took their responsibility for preventing this level of institutional corruption occurring again within the walls of the institution. So when one is outside counsel to an entity in a grand jury investigation, it's important to be creative and to think of ways to demonstrate to the Justice Department that the company takes it very seriously, has an ethical culture, not only at the top of the organization, but in the middle, and is willing to make tough decisions to demonstrate that, and that ultimately can improve outcomes in significant ways.
So, Nina, to return to my good friends Yates and Rosenstein, to what extent do you think that the objectives, in particular of the Yates memorandum, is being met? This is in response to a question from one of the delegates.
Yeah, I think I saw the question, and I think that overall the objectives are being met. I mean, they have certainly been codified in the U.S. Attorney Manual. So the objectives of the Yates Memorandum are certainly recognized, enforced, promoted, all of that. In terms of individual prosecutions as a component of the Yates Memorandum, I think as we've seen a rise in DPAs and NPAs since 2006, and we have seen a significant rise. So if you look at the numbers in 2006, you didn't see a lot of DPAs or NPAs, and as time has gone on, you see a lot more. And I think this goes back to what Katya was saying earlier, which is because of that, because we're not in court, you're not seeing as much prosecution of individuals as perhaps was intended by the Yates Memorandum. However, you know, to really say the Yates Memorandum was contemplating prosecution as opposed to identification, I'm not sure I would make that leap. So perhaps in that way, then the Yates Memorandum is being complied with because a foundation, cornerstone, bedrock, whatever you want to call it, to corporate cooperation and remediation is identifying the individuals. So I would say, as a general matter, the Yates Memorandum is being complied with. Again, it is the roadmap that the government is required to follow, and that hasn't changed.
One of the features in this area in the UK, well, in England and Wales at any rate, has been Bribery Act, and the Bribery Act driving a new attitude to corporate behaviour, and the need, as a consequence of the new offences and the attitude of the prosecution to bribery. So that has led to in one sense, a different direction and a greater sense of responsibility. And in Canada, do you perceive that whether it be GPAs or the legislation or indeed the codification of corporate responsibility or corporate liability and the senior officer test, do you think do you perceive that has led to proactive changes in terms of corporate response, or is the response typically only when a problem emerges and then it's remedial rather than cultural?
I would say to a very limited degree, it's had that impact. The biggest driver is big cases. So I can tell you from the Canadian experience, companies that have US exposure are much more acutely aware of robust compliance. And to some extent, the UK increasingly, actually, those with UK exposure, even Canadian companies with UK exposure are sensitive to increasing enforcement in the UK, and some pretty splashy headlines against some companies that people can look at and say, well, they do have a compliance infrastructure in place and they're still getting nailed. In Canada, there is if you're not exposed to those two jurisdictions, I would say there is still, I'm not sure I'd call it, well, maybe it's part complacency, and maybe it's a lack of understanding of exactly how deep corporate compliance needs to go in a larger organization and how difficult it can be. It's not just that superficial paper exercise with a training 1 hour once a year or something like that it goes much deeper, and it has to, if it's going to be successful. So I think it's the lack of cases. There have still only been a few, and there is increasing pressure for the DPA regime to be used more aggressively to try and drive some of that proactive approach to compliance. In fact, one of the things that struck me is an omission, a significant omission from the DPA regime. I don't know how it was missed in a sense, and it may be ironed out in the practice or in the practical application, but there is no requirement, or there is no statutory factor that speaks to the pre-existing state of compliance within the company as a mitigating factor. To me, that was a massive opportunity missed to try and really emphasize as you are much more likely to get a DPA if you had something resembling a robust compliance program from the get-go. I think that really would have been an opportunity to incentivize it. As it stands, that there is as I say, part complacency and perhaps part lack of understanding as to how robust it needs to be. So I would say the corporate cases are a necessary driver of cultural change. It's not just the statutory provisions, because I mean, you see it in other countries, that particularly in Latin America, some quite aggressive statutory provisions out there. But you know, the culture doesn't seem to have changed necessarily in some of those jurisdictions as well. And just because somebody's active in Argentina, where there seems to be a very aggressive paper program, doesn't mean that they're going to actually make change. It's enforcement that makes the change. You know, contrast that with companies present in Brazil. There has been a change there, I think, because they've seen actual on-the-ground enforcement by local authorities.
We've had another question which chimes exactly with what we've just been discussing. And Katya, I'm going to ask you, because of your experience in representing corporates. One of the ironies is that at a time when there appears to be a lot of companies in the news for the wrong reasons because of criminal infraction, one could end up thinking, well, this just shows that companies aren't taking any of this seriously, and they're only really responding when the bomb goes off. But to what extent did the guidance, the memoranda, and the climate, or the architecture that you've told us about at the outset, to what extent do you think that has actually affected the way that corporates conduct their business when the DOJ has not opened the door and shone the torch into the dark corner?
I think it depends on the company, Martin, and I think it depends on the size, the sophistication, the quality of its leadership. You know, I've had clients run the gamut, from extremely sophisticated leadership with a lot of savvy, who is willing to spend a lot of money on compliance, to companies that don't have the same level of sophistication and see compliance as a cost center and are grouchy about any suggestion that their compliance program should be augmented when there's no reason obvious to them to do so. No amount of DOJ guidance is going to change human nature. And so, one thing about the criminal defense business is that I think we will all always have cases to work on and people to represent, given just the repeating qualities of human nature. So I don't expect a lot of changes in that landscape, but I do think that DOJ itself has become much savvier about evaluating compliance programs. To Anthony's point, being able to suss out the paper programs versus the programs that are actually effective and operational and that work. And they've spent a lot of time and thought and energy on that. So when a company does build its compliance program, it really should keep that in mind, that a paper program with a 1-hour web-based training probably won't meet the mail should something happen. And I think all companies should prepare for that day, because human nature portends that day will come. So I think it's a wise investment on behalf of corporates.
I mean, that was number 5 on Nina's list. And do you think is that something, the adequacy of the compliance program, is that something that is likely to impact upon the decision of the prosecutor as to whether, for example, that a declination is the appropriate response? That there was in existence a corporate compliance strategy that went wrong on this occasion, or the individual was nevertheless still, despite discouragement, able to commit the offence. Is that going to impact on the prosecutorial discretion?
I would say absolutely. I would say the most critical things in terms of thinking about prosecutorial discretion and distilling down all of the guidance is having a compliance program that's robust, that's viewed as a journey by leadership, not a destination. It needs to change you know, all of the time. It needs to be responsive. It needs to respond to risk and be calibrated according to risk, not a one-size-fits-all program for all global operations. I think remediation is as equally important, and that includes employee action. So if you have an employee who's been engaged in bribery in a remote location, the type of actions that the company takes to that employee, to his or her supervisor, to that business unit in terms of remediation, all will loom large when the prosecutors determine what to do vis-a-vis the company.
Thanks for that, Katya. I wanted, there's two particular aspects that I wanted to have your views on before we look at some of the other questions. And also, if I talk for a little while, then it gives the opportunity for you to generate those not about to answer my question, and you don't know who it is, to look at some of the questions, because they are now coming in, and they're, if I may say so, very interesting. But two particular things. One, I want to know what the North American approach is in relation. You mentioned, Katya, about a company that the worst possible outcome is being found guilty of a federal felony. And Anthony, you also hinted at outcome or worst case outcomes. So what I want to know is what, quite apart from the sentence that a corporate can receive, the fines or whatever other sentencing options there are available, what discouragement is there against corporate criminal offending, in terms of the award of state or federal contracts? Anthony, what's the Canadian position?
It's massive. It's a massive issue in Canada. The Canadian federal procurement, what they call the integrity framework, which is a set of principles that are applied for bidding on federal government contracts, has a mandatory debarment consequence for a conviction under the CFPOA. It's one of the few offences that brings most of the offences, corporate criminal offending, result in a discretionary debarment, which is common to many Western jurisdictions. The Canadian one for a CFPOA charge has a mandatory consequence, and it can be massive. So in the SNC-Lavalin case, the biggest one to date, it became an existential issue, or the company framed it as an existential issue. We're very vocal in the media to say, look, if we are convicted of a CFPOA offence, we want to resolve this case. We're willing to do pretty much anything to resolve the case. But if we don't, and we are convicted under the CFPOA, about half our business is gone because we will face mandatory debarment. They were already under World Bank debarment. So the consequences, that consequence really drove some pretty vigorous activity. They did not get a DPA. And then the whole thing blew up. If anyone has some time, I won't go into it now, but if you Google SNC-Lavalin corruption Canada, you can read the story. But they ended up avoiding the mandatory debarment consequence because they pled guilty to fraud. It was agreed, it was a plea deal. They pled guilty to fraud, not corruption. So the individual at the centre of this was convicted of the CFPOA. And received the 8.5-year sentence. The company pled guilty to fraud and did not face the mandatory debarment consequence. So it can be a huge driver unless you get the Crown on board with an alternative plea. If you're not going to get it, a DPA avoids it completely. But if you're not going to get a DPA, then trying to go a different route in terms of the framing of the charge can be critical as well.
We've certainly, we can now all see that Amanda has just appeared. This is not to offer us further encouragement or to thank us or to thank you in particular for your contribution. It's to tell us off. It's to tell us that the time has come. I know that face.
Absolutely not. Absolutely not. I have to say, I expect Nina wants to go back to bed, but I think for everybody else, and maybe Katya too, but for everybody else, I am honestly so sure that we could carry on chatting and listening to you all for another hour. But time has run out, and this is one of the downsides, I think, of Zoom. The upside is that you're all here from all around the world. The downside is that you know, it's just deadlines that are harsh. But I want to thank Katya, Nina, Anthony and Martin for really an excellent and expert panel. As the saying goes, we are separated not just by a common language, but also a common law legal framework where we all are doing things in different ways. And I think that in itself is quite interesting. And thank you to the delegates. There's still time to register for Wednesday and Thursday. Another wonderful few sessions to come, and so I really do hope that we'll be seeing you tomorrow. Please do let us know what you think, and I look forward very much to seeing you all tomorrow, when actually I will be back again.
Thank you.
And thanks
Thank
to
you,
all.
everyone.
Thanks to all the panelists. It's been great.
Thank you. Be well, everyone.
Thanks, everyone.